The lawyers already got their share in collection. That money belongs to go straight to the operating account, no more legal fees. The other condition that's existing, title is transferred as a consequence of the unit being foreclosed by the association. If we were to foreclose on a unit that didn't have a mortgage for back maintenance, that money, the 3 months in escrow, goes to the operating account. If the title is transferred voluntarily or involuntarily, which is like in lieu of foreclosure, then that money is transferred also. If it's in lieu of foreclosure, it's transferred to the collection attorney, which applies it to their delinquent maintenance balance and reduces their balance. Legal fees are deducted, and then remaining money is forwarded to the operating account from our collection attorney. Bankruptcy is the same thing. Title is transferred by virtue of the lieu of foreclosure, or the one that we're adding to this amendment, and this is the whole addition to this amendment, is that if the owner becomes delinquent in the payment of any regular maintenance and/or special assessments, we can assign that 3 months of escrow maintenance directly to operating.
Is there a definition of delinquent?
Delinquent, yes. The definition in this here as delinquent is actually we can send a letter after, I think, 10 days.
What's your late fee date? What's the date the late fee is? Is it the 10th year or 15th?
The delinquency date that you can begin to
15.
okay. Owners, in event the tenant fails, no, that's how soon can we, what is the late? Good question.
I would say it's right after your late fee date.
So it's not 60 days or 90 days, it's day one after late fee.
It's okay. Technically, yes.
Well, certainly at 90 days. It doesn't give you how many days, but at 90 days, if we put a lien on it, that money should immediately go. At 90 days would go in.
I believe he said within 10
days. 10 days is the.
More immediate.
No, 10 days is the garnish rent. 10 days is the garnish rent. The delinquent rent and the definition of delinquent, which is not here.
The lawyer will tell us. Bro will tell us who created this.
I think it should say 30 or 60 days here. Why should we wait till 90? Then we got to pay Bro.
Well, we'll ask him.
Well, it should be before it goes to the attorney.
Yeah.
How many days? 60?
Technically, it should be going to the attorney at 45 days.
So we'll probably have to. He'll
So
tell
I would
us.
do
He'll
30
tell
days
us.
to be safe before it goes to the attorney. That way
Well, delinquent is
you buy
delinquent.
yourself another 3 months
Yeah.
before having to go to the attorney.
It doesn't seem like you have to wait 90 days, then you got to pay Bro 500.
He was
That's what I'm
talking.
saying, 30 days.
He was talking about earlier.
Well, that,
What we can do is vote to accept this and then, to check with Bro. Within 30 days.
there
After 30
should be a
days.
time in there.
After 30 days, and we'll double check.
30 days. Where are you inserting the 30 days? 45 days.
Under III, under F, the part of the amendment that says F, where the second page, owner becomes delinquent, paragraph under that.
Which paragraph?
F is the insertion here.
So the owner becomes delinquent with the payment with which assessment. So everything in parentheses is delinquency more than 30 days.
Oh, that's where you put it from one.
Yeah.
In the underlines.
We need to double check this with Bro, Michael, because
Well, we have a letter.
he had a time period in mind, okay? An early time period for us, so. We just need to vote it yes and then, also.
Yeah, to define
It's there
delinquent.
too. I mean, if you have 3 months of association maintenance, that's why people say 90 days, because it's 3 months. However, you're accumulating more term fees. At that point, you're accumulating.
That's right, so it should be as early as possible. If that, he will tell us. And I believe he have something very important.
As an attorney, he's probably gonna tell you the 90 days, so he can add. more
Right,
fees.
I think 60 would be just right.
So I just wanna,
45 to
Right
60.
now, we have 30, 60, and 90.
45 is the majority.
30, my recommendation is
30 days.
Well, a lot of people might have waited 30 days, and then you're gonna have a huge bookkeeping problem, because you're gonna take all the 3 months maintenance out, and then they gotta replenish it.
Not necessarily, it just gives you more leeway. What you do,
30
doing 30 gives you
months of credit on it.
gives you choices.
That'll be a bookkeeping nightmare. I would say 60 days, replenish the 3
Well,
months.
after 30 days, you still have to send a letter.
Well, with the letter, then will be followed by a notarized demand. Demand letter, certified demand letter, which makes it about 45. After 30, you get the late notice, and then you get the demand letter.
But the demand letter comes to the attorney, so the answer.
Oh, yeah, try to avoid that expense. If it had a time in there like 45 days, then we don't have to delay or anything, you just transfer it.
But we still have to send an amendment.
Why don't you
You
just
still have to,
specify?
we have a form letter to tell them we're applying it to their thing. We have that here, a form letter from, that we send out, and how many days?
You could
Is
specify
that up to us?
at the time before it goes to the attorney. So in other words, you do it before you send it to the attorney.
Yeah, well, you can see what broke like in 90, and and it would benefit us if we did it
I don't
sooner.
think he wants it at 9, he did something else at 9, we just don't know what it is, so I think we have to vote to accept this, send it to the people, and verify withdraw the earliest.
Defining delinquent. Right, you can-
Yeah, definitely, earliest delinquency, we should be on.
Yeah, somewhere around 30, 45 days.
Yeah, but we have to check
Well,
with him.
approve this and then we'll define the time period.
Exactly.
Okay, so, I want to make a motion to approve this.
Okay, so the motion will be that the board approve proposed amendment of Article 16B2, declaration, and send it to the membership for vote, providing for the declaration of condominium. Is there a qualification?
And to,
Determine the definition of delinquent for transfer.
Motion
So we would accept it. And we'll, the definition of delinquent. A date. How many
and
days?
to set the time of delinquency.
Determination of delinquency.
It sounds like the association could decide when it's delinquent according to.
Right, well, let's get the opinion from the attorney.
Yeah.
So,
Attorneys.
So, attorney opinion up to us.
I would say around 35 to 45, somewhere else.
Okay, so be subject to attorney's definition of delinquency. For what?
When someone's considered.
Subject to attorney's definition of delinquency.
Exactly.
Well, it's not, his definition, his benefit would be 90 days, so he may not be mentioning,
We don't have to.
we just want to know if it's okay if we implement
We
this
don't have to
rule.
agree with it.
Right.
Which one is that for 40 days?
No, we don't need to set a time limit, it can be case by case, and you can implement it as you need it.
No, I wouldn't.
No, you have to
Well, after a certain
It's
date.
got, no, it's got to be certain, it's got to be a date. You're doing an amendment to the.
That's a bigger
No,
one.
it's got to be a certain, you can't.
So leave it subject to the attorney.
Well, you know, you don't want to say 45 days because he may tell us.
Okay, that makes sense, a letter that you're late.
I would be willing to put in for more than 30 days. It doesn't mean we have to do it.
All right, that's good.
Put it in for 35 days.
30
No,
days,
no,
gives you more leeway.
More than 30 days.
For more than 30 days.
More than 30 days.
We always have the
More
option.
than 30 days.
More than 30
More than
days.
30 days. And then you're gonna send a certified letter.
So the only change, and it's going to read exactly the way it is now, except that at the end of special assessment, it's going to be read for more than 30 days.
Exactly.
That's
More than 30
I like
days.
that.
That's right, that's excellent.
What is special assessment? More than 30 days.
It's already here. It's already written down. We're
That's
just adding.
very flexible. That's flexible. That's very good. I like that.
But, you know, some people
So
are,
shall we take a vote?
some people are delinquent.
Okay, let's vote and get on.
Okay.
Yes. The motion has been made. The motion was made by Michael and seconded by, made made by Paul and seconded by Michael. Okay, this is, XB1, B2, right? You have 16. You have so it's by Paul and seconded by Michael.
Absolutely.
Yes. There should be a minimum amount. Some people are delinquent $50, $80 each month.
After 30 days, these are totally attorney's credit.
Very flexible.
Yeah, right.
You're not going to charge me for 30 days.
Okay, next,
please.
Next. This is also an amendment,
What number are we talking about?
last one.
Oh, good.
Very important.
This is an entirely new amendment.
Please.
This is an entirely new amendment, and the amendment is to collateral assignment of rents. In the event an apartment owner is in default of payment of any delinquent assessments, common expenses, association shall have the authority to collect rents directly from the apartment owner's tenants. Such rental payments shall be collected in accordance with procedures established by the Board of Directors and applied in accordance with Article 16 of this declaration. Each apartment owner shall be governed by and shall comply with the Act and all condominium documents as they may exist from time to time. Failure to do so shall entitle the association, any apartment owner, and any approved mortgagee holder encumbering any apartment to, this is the new language. In the event an apartment owner is in default in payment of assessments for common expenses, the association shall have the right to collect the rents directly from the apartment owner's tenant. And in the event the tenant fails to remit said rent directly to the association upon the earliest of 10 days from the date the association hand delivers a demand letter for said rent, or posted a demand letter on the apartment's front door, or notify the tenant in person or by telephone that said rent must be remitted directly to the association. The date the next payment is due. The association shall have the right to terminate the lease and evict the tenant, or for the purpose of such eviction, the association shall be deemed to be an agent of the landlord.
This language has been approved by our attorney.
This is written by our collection attorney, and this is an amendment which the purpose of is, in addition to the lease application and the sales and purchase applications, which spells this out in the application that you have to put this, have to agree to this, and it has to be notarized by the owner. It does not have to be notarized by the owner and the tenant, according to Bro 2 or 3 days ago. It only has to be notarized by the owner. And there's an addendum page which goes with all our applications, which includes this addendum. As a side note, we're hoping to have a notary in the office that we're going to, one of our office staff or two will have to be notaries so that this can be done very easily. And that's an addendum to the lease. This is an amendment to our condo documents, which reinforces the amendment to the lease and puts more teeth in it for the purpose of legal collection.
I vote yes.
Me too. Okay, can we take a vote? Give me the motion.
Thank you.
I second whatever you say.
Marvin, you're so infectious.
The motion is on the sheet.
Move things along.
Motion sheet. Yeah. It's the motion that the board approve proposed amendment of Article 16 of the Declaration, etc., adding a new section B6, and send it to the membership for vote as provided in the Declaration of Condemnation. The motion was made by Michael.
And I second.
And this is how we're going to balance our budget. We've already done.
Michael, do you like, are there
tenants paying rent to the association right now, about $1,600 a month. We need about 40 more, and we're gonna get
Any
it.
volunteers?
Well, okay, now, please, we have to move on.
One more.
We also are compelled to amend our bylaws because of the new state law, which restricts the term of directors on the board to no more than 2 years. At the present time, our documents provide for 3-year terms, which are staggered. So in order to comply with the statute, we must have the members make a selection as to the length of term that the directors shall serve. The vote,
2 years is fine, 1 year is not enough.
No,
it's just voting.
I was gonna say, you have to direct, vote.
so what we must do,
But it's just a second paragraph. It's also the amendment to second.
2 separate things, 2 separate provisions. First, they have to decide how many years the directors will serve. Then the apportionment of the vote whether it's going to be split or something is a totally different matter, and also whether the
We can decide right now.
we may decide on consecutive terms, but we've got to do it in order, please. So the first motion is that we motion to send the ballot to the membership so that they may vote for either 1-year terms for directors or 2 years terms for
Which is
directors.
the maximum by state statute.
This is because of the new state statute. We must do this. It already, the preamble is, in view of the new statute restrictions, restricting terms of officers, for motion that the board approve proposed amendment of Article XBB2 of the Declaration of Condominium and send it to the membership for vote as provided for the declaration. It's just the preamble.
Can I ask a
Well, we're gonna vote first as a board.
Is that
Why don't we just vote for 2 years, and then they can say yes or no?
No, what we're doing is we are approving sending the ballot to the membership for their election. The board has no right to make this selection for the members.
But in any event, we cannot be contrary to state statute, whether the association.
We cannot be contrary to the
If the
statute.
membership knocks it down, it
With
doesn't,
the-
it's moot.
The membership has nothing to knock down. They're going to vote for 1 year or for 2 years. They're not voting for, they are selecting.
Whether it's to be 1 or 2. Okay.
They're not knocking anything down. They must,
So,
Francis, is that made by you, or is it?
no, I don't make motions. Hold on.
Looking at motion.
Hold on.
I'll make that motion.
Wait.
To send it to,
I'll second it.
I'll make the motion that we comply with state statute.
Yeah, it doesn't seem like we need to, maybe I can comply.
No, we can't. Statutes are still.
You can all get the 2 years and then all 1 year.
no, it says you can have 2.
There's not maximum. You do anything you want.
But no more than 2.
2 years.
Yeah, but you can do 6 months if you want, but it can't be more than 2 years.
Let's miss said. It has to be sent to the.
Okay, can we move on, please? Okay, so, the motion was made, and
seconded by Michael.
anybody opposed? There's nothing to oppose.
That's those guys.
This is put before the membership.
Yes, it goes to the membership.
So the
They all
vote
go to the
is, the
membership.
vote is to send the option up to the membership.
To send them the ballot. Okay, so it's unanimous.
For 1 year.
Okay, next. We have another one?
Yes, yes, we should at least bring this up now or we won't get to square one. And that is, in our docs now, under the 3-year term basis. We have a limit on consecutive terms that directors can serve. Right now, directors can serve 2 consecutive 3-year terms. Then they've got to take a break, okay? So, now what we're suggesting is to put into, change that language to 2 consecutive 2-year terms, which would be a total of 4 years in office, and then whatever director would have to take a break. So that brings it down from 6 to 4. I personally like that number better. If it were like 1, if it were 1 year, if the membership didn't vote for 2 years, but 1 year for a single term, then they could have 3 or 4 consecutive 1 year. Not to exceed 4 years.
4 consecutive
4 consecutive years.
years. Period.
Seems better than 6. So I'm putting it out there, that's what
One
we
consecutive
would like
Or
to.
consecutive years.
4 consecutive years, so this way it's not a 1 year or a 2 year.
Exactly.
Make a motion.
1 year.
I make a motion that we amend our current docs and send this out to membership for vote, that directors, the amount of directors' consecutive terms can only be, amount of consecutive years can only be 4 years.
Is that another amendment? Is that a separate amendment?
This is a separate amendment.
How many amendments do we have?
This one's required by,
Well, I don't have a copy of the amendment.
Saying he's gonna take.
Yeah.
Do we vote?
The last time
He's gonna criticize every amendment.
2 2-year terms, right here. Or the alternative.
Saying, well, no one enforces consecutive.
glad you're getting out.
Steve, does there have to be a certain amount of responses? There does. So if you're gonna overburden the ownership with 10 or 12 things, a lot of people aren't going to do it. You know?
People around here. Has to be a couple.
It's not clear.